Good afternoon, everybody. My name is Chris Justice, and I'm joining you here all again to answer as many questions as I can, employment law related. So definitely, if you've got any questions regarding your workplace, maybe it's a contract you're curious about, maybe you've been let go and you're wondering if the severance you were given was fair, or perhaps you're going through some issues within the workplace while you're working there as an employee. Definitely get your questions in. Happy to answer as many as I can. And as I usually do in these instances, I'll start off with a little bit of a talking point before I get into some of the questions. This time around, I wanted to talk a little bit about performance improvement plans because I still get constantly messages, phone calls from people who are, working for a particular company, and then all of a sudden they get presented with a performance improvement plan by their employer. They are told that their performance is not up to par, that there are a number of, criticisms or issues that their employer has with them. And in many cases, these situations can sort of be a scenario where the employer is potentially setting themselves up to terminate your employment later on down the road, depending on how you respond to the performance improvement plan and depending on your employment overall. So just as a quick primer, a performance improvement plan is basically something that your employer will give with the intention of usually trying to improve your performance or offer some sort of assistance to improve your performance in the workplace. And a lot of times what's in the performance improvement plan as far as the criticisms are concerned require a bit more examination. And I think it's helpful to give people a general idea as far as how they should actually respond to being placed on a performance improvement plan. So I wanted to touch on a few key points there. So the first thing has to do with the criticisms themselves, either being subjective or objective. So if the performance criticism is more of an objective issue, then usually it's going to be more black and white. There's going to be a metric or a standard. Maybe you haven't hit a certain number of sales per month or in the year, or there's some sort of fact that has occurred that is just without any dispute. There's no interpretation of it. It just is what it is. And then on the other hand, you have more subjective performance criticisms, something that may be based on your manager's opinion more so than what the stats show, something that isn't going to be as easily measurable. So in some examples, I've seen managers go to the employee and say that they're not being a team player. Sometimes they're being told that their communication isn't up to where it needs to be. And these sort of criticisms, as I say, are a lot of times based on opinion or not something measurable. Maybe they're open to interpretation. And, what a team player is to one person may not be what a team player is to others. And I find that when the primary basis of the performance improvement plan centers around more of these subjective criticisms that are open to interpretation or not as easily measurable, that's when the criticism itself can be abused, and when employers can abuse the process of a performance improvement plan by focusing only on subjective criticisms and not necessarily objective. And so that's one thing I think people need to be aware of. I think that when you're given a criticism that's subjective, that isn't clear, or it's somehow vague in some sense, you need to be asking in writing for more clarity. What is it that you mean when you say I'm not a team player? What is it that you mean when you say I don't communicate as well with coworkers, or that my conduct within the workplace isn't, suitable for the company's motto or MO. So nailing down, getting clarification on these things is going to be very important. Asking for more detail, because otherwise they're just going to have some vague allegation out there without any clarity, and without you responding to it in writing and asking for clarification. That allows the employer themselves to set the stage and to control the narrative in some respect, so that if they do let you go later on down the road based on these subjective criticisms, there's nothing on record from you pushing back or asking for clarification, or, as I say, objecting in some sense. So getting those details is important. even frankly, when it comes to objective criticism. So if somebody says that you're not meeting a certain sales metric, or you're not bringing in a certain amount of money for the company, you also want to make sure that what they're actually expecting of you is realistic. So sometimes the criticism can be actually very clear, but not grounded in any sort of realism. It can be maybe an unattainable or an unachievable goal is being set for you in your performance review, that even with continued performance that's good on your part, you're still not going to reach this goal. And I think that also, again, in writing, is something that should be clarified by you, or at least set out in writing to say that these metrics, these measurements, or these expectations are not realistic, even if they are clear. And here's why. And again, providing some further pushback so that, if the employer does, again, rely on that later on down the road to let you go, you have a paper trail, a written record showing your pushback, showing your dissent, maybe asking for clarification. And if they don't provide that clarification and they just keep it as is, then you're going to have more leverage later on if they try and sort of use that stuff against you. So be wary of the types of criticisms that are launched at you when it comes to a performance improvement plan, as far as I say, subjective versus objective. But in general, if you've been given a performance improvement plan, you do need to take proactive steps to protect your interests. You should be responding in writing to the criticisms, either to say that you acknowledge the criticism and you're working towards bettering yourself, or to potentially say that the criticism isn't even accurate. Sometimes, as much as we may not want to have it be the case, there are criticisms that are levied against you that are just not grounded in any reality, and you need to be able to set out in writing your objection, your pushback to those things. So you don't want to be quiet when it comes to these PIPs, these performance improvement plans. Your silence is going to likely be held against you. And as I say, it's going to allow the employer to set the stage, to control that narrative, and whatever's in writing is only going to be coming from their end, not yours. And that's going to look bad, even if later on down the road you do raise these as an issue to a lawyer, let's say, or you do try to push back against them, but you just didn't respond when they were given to you maybe months or years ago. So putting things in writing, pushing back to either say, no, you're incorrect, or I need more clarification, or yes, I acknowledge this criticism. However, you're not considering this other piece of information. Because sometimes a criticism can actually be valid and correct, but not taken in the right context. So maybe there's a specific reason for why you are not performing up to par, or some basis as to why you're not meeting a certain metric that you should also make your employer aware of. I know in a lot of cases, for example, people have, say, medical conditions or religious obligations or other things that might be covered under the human rights umbrella that prevent them from being able to reach that certain standard or expectation that's placed on them. And that's another thing that you're going to want to highlight in your response to a criticism, if there is a valid justification for why you can't do something. Because if it's actually a disability or something, as I say, under that human rights umbrella that is affecting your ability to reach that standard or that expectation, then your employer is going to be a lot less likely to be able to rely on that later to let you go, without at least first acknowledging your comment and trying to accommodate your situation. And again, taking all the context into consideration. So you definitely want to make your voice heard, and make sure that you have a paper trail in writing. It's not going to be good enough to simply have discussions with your employer when it comes to things around performance improvement or criticisms, because then you're going to be left in this he said, she said position where you're saying that you had a verbal chat maybe with your manager, but then lo and behold, you find out that your manager is now all of a sudden saying that that conversation never happened, or that they have a different recollection of that conversation. That's why putting those things in writing is very important, because that could actually prevent a termination from happening altogether. Or if the termination does still happen, even after you do put forward your response to the criticisms, it's going to make it a lot more difficult for your employer, if they're going to let you go, to do so without any severance. They're still going to be likely then obligated to pay you at your full severance. And again, that's where your responses and putting everything in your feedback in writing is going to come in hand. So documenting things in any case, really, for that matter, is hugely beneficial and appropriate. There are some other key considerations to think about when you're given a performance improvement plan. So oftentimes I'll also see situations where somebody is given a performance improvement plan and they're told that if their performance doesn't improve within a week or a month or a couple months, that they may be let go. And so the issue of how much time your employer gives you to correct any issues that might exist can be problematic, because a lot of times they don't give you a lot of time. And maybe to expect for there to be improvement could take a number of months. And yet you find yourself in a scenario where your employer is only giving you 30 days to reach this certain standard. So be wary also of the time frame you're given, because that time frame also can be unrealistic. You may not be able to achieve what they're expecting within the time frame, and it may be reasonable to ask, if it's applicable, for more time before they take any sort of certain action. The last thing I'll say is always try to have a plan B in place. So if you're given a performance improvement plan and you're worried that maybe the writing's on the wall, maybe your employer is going to plan months down the line to let you go, and that they're trying to build up a case against you, having a plan B in effect by looking for other potential jobs at the same time, just to safeguard against the possibility that you could lose the one you have, is another recommendation. And that way, if it does come to a point where your employer decides to let you go for reasons relating to the performance improvement plan, you're not all of a sudden sort of in a bind, because now you're having to scramble to get another job. And, you're hoping, I suppose, on one hand to get more severance, but you're now without a job, you're not with any money. And so it can put a lot more stress on you if that's the case. So having that plan B in place to begin that search, like I say, can be definitely beneficial if you do lose your job, because then it could hopefully take you less time to find a job. And now you're not having to put all your eggs in the basket of them doing the right thing and giving you the severance that you're owed. You've got a sort of a contingency plan in place. But I think in general, if you're being met with a performance improvement plan, especially one that you have a lot of issues with or disagreements on, apart from what I said, of course, it's always good to get some legal advice. Give us a call. We do this day in, day out, as far as guiding people through how to communicate with their employer when it comes to performance improvement plans, what to put in writing, and all that kind of stuff. Because, as I say, that can be very important later on down the line when you're looking at the back and forth between you and your employer. And sometimes people don't see a lawyer, don't get any legal advice, and they have a number of different conversations with their employer about the performance. And then only months later, for instance, do they come and see a lawyer. And now that lawyer has to sort of work with what's been said as of that day. And sometimes people do end up saying things unbeknownst to them that are detrimental essentially to the case, and can put them in a bit more of a difficult situation if they are let go and, for example, not given any severance and having to then deal with it after the fact. So definitely give us a call if you're in this sort of a situation. But I just know that these situations do come up a lot, and it's important, as I say, to kind of highlight some key considerations people need to look at in terms of responding to these sort of PIPs, as they call them. But I'll get into some more of my talking points if I have some time, but I do want to answer some of the questions that have come in. So I've got one from L on Facebook, who's saying that their employer is planning to reduce their commission structure. This person's in a sales role for doing the same job. They've worked at the company for 22 years. And under this new commission structure, they are being told that they will guarantee 2 years of current pay before drastically reducing it. And the question is being asked if they can terminate me at any time if I'm not performing well. And if they do terminate me, am I still entitled to severance? So just to answer those last two questions, you can be terminated at any time if you're not performing well. In fact, employers can terminate your employment for pretty much any reason they want, even if it's not a good reason, as long as they usually provide you with your severance. A lot of times, though, if they terminate you without providing any severance, they've got to show that something either extremely bad happened where you engaged in some serious misconduct, or perhaps that you had failed to meet their standards over a number of months or longer, despite many, many warnings, and again, assuming it's all true. So there's very, very limited situations where an employer can let you go without any severance. Most of the time, you're going to be owed severance, but that's not to say that they can't terminate you at any time. It's just a question of what they do afterwards, whether they give you a fair package or not. As far as the change to the commission structure, though, normally when someone is faced with a change, especially a significant change in terms of, could be compensation, could be where they're located, where they have to commute, let's say, or it could just be to the job in general. Employers have to, if they're going to make big changes, they have to give you notice. And if they don't give you notice and they simply tell you that, for example, next week we're going to be changing the commission structure and it's going to result in, say you losing 30% of your income or more, that's when it becomes a problem, because you literally have no time to sort of try to find other work after the changes happened, and you're sort of left in the lurch. But where employers give you a sufficient amount of notice that a change is coming, then they can be allowed to make changes. So, for example, if my employer told me, hey, Chris, you're making $100,000 a year, but we're going to change it now to $50,000 a year starting next month, that's going to be likely a big issue, and that's going to likely be viewed as a termination of my employment, for which I would be owed severance if I object to that change. But if my employer says, hey, Chris, you're making $100,000 a year, and we're going to make sure that you keep making $100,000 a year, but 2 years from now, it's going to go down to $50,000, then the company is more likely going to be able to do that, even though it is a big change, because they gave you so much notice. And so the point of them giving you the notice, especially 2 years of notice, is to give you time to decide essentially whether or not you want to agree to that structure or not. And if you don't agree to it, then you can spend the next 2 years looking for another job that pays what you're getting right now. And so that's why, as I say, if you're given a long period of notice, that might be different. Those changes can happen. It's just usually in most cases, people aren't given any notice, or they're given very little notice. And that's what the law frowns upon. And that's when the law would step in and usually say, there's been a constructive dismissal here. You've made a unilateral change to someone's employment effective immediately or very soon. And now they either have to decide whether they accept it in this short period of time or leave. But if they leave, then of course they're without any job, and now they got to spend potentially several months looking for a job. Whereas if you're given 2 years of notice or something that would be sufficient, the law doesn't object to that so much, because, as I say, you have time to, if you don't agree to the change, you have time to look for other work. And the idea would be that if you're looking for a couple years, that you should be able to find something that pays the same. So Elle, in your particular case, there may not be a whole lot you can do just given the amount of notice they've given you. But in any event, if you do want to chat about it more, maybe give some more details around what exactly is happening, how the commission structure is changing, and how long you even think, practically speaking, would take to go out and find a job that pays the same as what you're making right now, we can definitely chat with that with you through a consultation, and ultimately decide whether or not it's in your best interest to push back and maybe go after the company for possible severance and treat this like a termination, or if it's more advisable to spend the next 2 years looking for something else if you're not on board with this commission structure change. But definitely give us a shout if you have any further questions, Ellen, and thanks for the question. I've got another one from Munir on YouTube, who's saying that their friend got fired last week after 26 years, so a very long time, and they were offered 26 weeks, I assume of severance. And they mentioned that this offer is being given to them on a without prejudice basis. So anytime a company says without prejudice, that they're offering you something without prejudice, what they mean by that is that they're trying to reserve their right to go back and say that they don't want to give it to you. So they're offering it without prejudice in the sense of maybe they don't believe you're owed that money, but they're giving it to you without prejudice to their belief. So that later on, if they want to argue that maybe you're not entitled to this money or any money for that matter, putting a without prejudice clause or mentioning without prejudice would allow them to raise that later on. So normally, though, 26 weeks for a 26-year employee is very, very, very low. In fact, a 26-year employee can get upwards of 2 years of severance, not just 26 weeks. So we're talking quadruple the amount. The only way that the employer would be able to argue that a 26-year employee is offered something like 26 weeks, which, as I say, is typically very, very much on the low end, is if your friend was fired for doing something very bad. So there could be an instance where I work for a company for 26 years and I get caught stealing from the company for several months, or I lie to the company on multiple occasions and they let me go because they can't trust me anymore. It could be the case that even after all those years, I'm owed $0 because what I did was so bad that the law would punish me for it. And so I don't know, Munir, if there's some sort of situation in this case where the employer perhaps believes that your friend is not owed any money based on certain allegations against that person, and that therefore that's why they're offering this 26 weeks on a without prejudice basis. Because normally, if there's no issue in terms of performance or that nothing bad happened in the workplace and you're just simply let go without cause, like say, for instance, due to a reorganization or a restructuring within the company, then a 26-year employee in the vast majority of cases should be getting probably at least a year and a half, not just, if not more, not just the 26 weeks. So you may want to give us a call or have your friend give us a call, Munir, just to get a sense of why this person was fired, why exactly after that many years they're only being offered such a little amount of money. Because, normally I would say there's a lot of money to be had in this case, that you shouldn't accept this offer, at least not without first speaking to a lawyer, so that we can kind of better understand the context surrounding this. But anytime someone's been in a company for 26 years and they're only given 6 months as an example of severance, alarm bells are going to be ringing in my head. And I'm going to be thinking that there's a big problem here and that this guy or this girl is owed a lot more money. But again, it'll come down to some of the circumstances surrounding the termination. So definitely have that person give us a call and we can give them the proper advice and assess kind of what the best option would be going forward. I got another question in from Joe, who's asking what you can do if your employer has said they won't bring you back after a parental leave. So again, alarm bells would be ringing in my head if I go off on a paternity leave or maternity leave or disability leave or any leave usually that's protected under human rights or under employment laws, and then I don't have a job to come back to and I essentially lose my job. My mind would be thinking, well, did I lose a job because I went on this leave? Had I not gone on this parental leave, would I still have my job? And if that's the case, and taking the leave had something to do with the termination, even if it's partially, then being let go in a circumstance like that, or being told that there's no job for you to go back to, could result in a termination in the eyes of the law and entitle that person to their full severance, as well as possible human rights damages if it is found that the parental leave had something to do or formed some rationale behind why the person was let go. Even if it's just 1% of the reason someone was let go had to do with taking a leave, then the employer is going to be in a lot more hot water than just having to pay that person's full severance. So again, Joe, that would be another situation where you want to give us a call, because you're looking at, it seems like, the prospect of having no job, no severance, and there being no other alternative. And so there could be tens of thousands of dollars, if not more, on the line here that the employer may have to pay. And what they're doing could be, very much an egregious thing. So give us a shout, because there are some concerns with that. But again, it might be something to delve a bit deeper in during a consultation and sort of flesh out all the issues there so that we can properly assess it going forward. I've got another one in from Peter, who's saying, if a doctor puts you on a medical leave due to stress from your job and your health doesn't get better, do you have to go back to the workplace if it's affecting your health that much? The answer would be no. I think if it's in the advice of your doctors or treatment providers that you don't go back to the workplace, I think for the most part, you should defer to the experts there. And until you are able to go back to that workplace and be in a better state of mind, let's say, your employer is going to have to accommodate your absence. So they can't necessarily force you to go back, or maybe you're off for a while and then they say, sort of like in Joe's case, oh, you've been off for so long, we don't have a position for you anymore or whatnot. Then that can be a huge issue that you might be owed a lot of money for. But yeah, ultimately, if the health doesn't get better, then it probably doesn't make sense to be going back into the workplace. And so you should focus on getting better. And depending on what your issues are, whether they're specific to the workplace, then you may want to potentially look into how you can go back to a more safe or conducive workplace, if that's possible. Or if your condition is not related to the workplace and it's external to that, then it may just be a matter of getting back to where you were and then going back at that point. But again, probably something to flesh out a bit more with us as far as what it is about the job that is stressing you out. Is it something that happened in the workplace that's above, the ordinary circumstance of just regular job stress? Maybe your manager's harassing you, or there's some sort of issue that you have with a particular individual there, so that, you could only come back if some accommodation is made in that respect. But any kind of accommodation you ask for as well, generally your employer has to do its utmost to accommodate you. So that could be having you work less hours for a period of time, maybe have you report to a different person within the company if there's a problem with you and another specific individual. So there's got to be a lot of times something done on the employer's end to try to accommodate you and get you back into that workplace efficiently and effectively. But there are a lot of instances where they don't want to accommodate, or they don't have a job for you after you've been off for a while. And that's, as I say, when employers can get into a lot of hot water, because then they're going to be on the hook potentially to pay you damages for the way in which they treated you, but also severance in the sense that you'd been let go. I've got another one in from Brennan, who's saying that their employer laid them off a couple months ago. They worked for about 2.5 years. They were called an independent contractor, but they don't think that they actually were, and they're asking how they should go about it. So yeah, a lot of times people are called independent contractors, but they're just not. In fact, they don't decide. The employer doesn't decide if you're a contractor. You don't decide if you're a contractor. The law decides. And a lot of times, even if you have your own company, you pay your own taxes, maybe you send invoices to the company for your work performed, and there's some things that might be unusual that a sort of a regular, so to speak, employee wouldn't have to be doing or be doing in any case. Those are just part of the factors that go into the equation. And in fact, in the vast majority of cases, when people are being called independent contractors, they're actually not. And the law does consider themselves to be an employee. And so if you've been let go after 2.5 years as a so-called contractor, there's a high likelihood that you're actually an employee and that you would be owed severance that would normally be in line with a 2.5-year employee, which could be 3, 4, 5, 6 months of severance, depending on who you are. So I think, Brennan, you should give us a call so we can kind of get into the details of whether or not you would be seen as a contractor or not. If you are a true independent contractor, you may not be owed any severance, but the vast majority of cases, this isn't the case. So definitely makes sense to give us a shout, and we can kind of guide you through it, figure out what the potential gain is for you there, rather than, walking away from it and, again, potentially throwing away tens of thousands of dollars. I've got another question in from Chance on YouTube, who's saying that their son started a summer job. He's 15 years of age, and his employer told him that since he's so young, he doesn't need to receive a minimum wage, and they're only paying him $10 an hour, and they're wondering if this is allowed. So yeah, unfortunately, in a lot of these cases, people have a certain idea of what people should be paid, but they are still going to be guaranteed certain minimum wages. And if those wages aren't adhered to, then there could be easily a violation of the Employment Standards Act, of legislation relating to employment. So I would say that you should definitely give us a call as well, Chance, because likelihood is it's not allowed, that there's a breach here, not only of your employment, but as I say, potentially of legislation and of regulations within the province. And so this employer could also be in hot water. Because there often is a mistaken belief that because someone's a summer job student or of a certain age, they're not entitled to something, but it's just a mistaken belief, and they actually are. So there might be retroactive pay owed, and then some. So Chance, just like the others, I think you should give us a shout, and we can have a consultation set up and kind of guide you through that process. I've got just a couple follow-up to some of the other questions that I'll answer just before my time comes to a wrap. So L is saying that they want to contribute to the cost administrative load by deducting 10% off the commissions. Is that something they can do? And if they terminate me during the 2 years of guaranteed, am I entitled to severance pay? So yeah, if they terminate you during the sort of the notice period, so to speak, and they cut it short, then you would be entitled to severance pay because that would have been the first time a termination took place. And the question would just be, at the time you've been let go, what were your earnings and what were they expected to be for, say, the months or years past that point? So if they cut you short early on in that 2 years, then they're likely going to have to pay you severance based on your current earnings, versus cutting you short after the 2 years are up. They may more likely be able to rely on the lower compensation that they, I suppose, warned you about would come into effect. Deducting 10% off your commissions, is that something they can do? The question is, how much does that translate to in dollars and cents? So if I make $100,000 a year and 20% of that 100,000 are my commissions and they're taking 10% off the 20, then they're essentially lowering my wages by $2,000 a year. And that's likely not going to be seen as too big of a deduction to constitute a termination at law. Usually when it comes to deductions being made to your pay or your wages, in order for you to essentially take a stand and say, no, I don't agree to it, and I want my severance because I think this deduction represents a termination, you got to be looking at around the 15% total wage range. So if you're making $100K a year and they reduce your wages by 15 or 20 grand, that alone is going to constitute a constructive dismissal, and you could have the opportunity to take a stand there and treat that as a termination. But if, as I say, you're making 100 grand and they deduct it by $2,000, that's probably not going to be a big enough deduction for you to sort of walk out and leave and insist on your severance. So it'll just come down to the proportion that it takes up of your wages. And then just the last thing from Peter, who had earlier sent in a comment about going off on a medical leave due to stress. Do you have to go back to the workplace if your health is being affected? Peter's saying that, or is asking whether they have to legally go back because of their health issues relate to management. So would I be legally okay not to go back, period, because of the issues at work affecting me? The question is, again, going to depend on what you mean by issues relating to management. Is this a manager that is just, micromanaging? Is this a manager that's harassing you? Is this a manager that you can avoid if you can come back and not have to report to this manager and completely avoid them and report to another manager? You're seeming to suggest that it's isolated to a certain management style. So the question is going to be, if you have an issue with a particular way you're interacting with someone at the company, can the company accommodate you if you go back, in the sense of you not having to report to that person? Is there something that the company can do to have you back where you're not going to be encountering these issues? And if they can do that and they can accommodate you and they can sort of almost guarantee or assure you that you're not going to be having these issues with management anymore, then legally speaking, you may be expected to go back. And if you don't go back, you may be seen as having quit your job. On the other hand, if the issues are not something that are being accommodated and they don't want to make any changes for your return to work, and you know that if you go back, you're still going to be encountering those same issues guaranteed, then you may have more of a leg to stand on when it comes to severance, or at least when it comes to sort of taking a stand and saying, this isn't acceptable, and then having a lawyer get involved and treating that almost like a failure to accommodate you. So again, it's just going to depend on the specific health issues, the specific issues within the workplace, and what can be done there. So again, I would say, Peter, give us a shout, because it does seem like there are very fine details in this case that could affect whether or not you would be okay to say, no, I'm not going back, period, and whether that would put you at risk or not. Because there are instances where you can take that stand and say, I'm not going back, and I'm treating this as a termination. And then there's other instances where you say, I don't want to go back under any circumstance, but the lawyer might be telling you that that's a more of a risk for you based on the particulars of your situation. But definitely give us a shout, because if you don't want to go back either way, then you may be considering just walking away without anything And I would say that would be a shame if you do have more of a leg to stand on. And as I say, if a lawyer can help you out and give you some insight as well, then you might be in a position where you can get a package from them, because the risk is going to be higher on them from a legal perspective, and that can be used as leverage. But that'll do it for today, everyone. I thank you all for joining. Appreciate all your questions. As I say, for those that I was asking for more details, give us a shout. We can definitely help you out either way. And down below there, you can see where we're got another Q&A going on Friday, July 19th with Teelan. So anyone who has a question, didn't get answered, or has a question in any case, tune in on Friday, and Teelan will be happy to answer your questions at that point. But for now, I'm signing off. So thanks again, everyone. Do take care and enjoy the rest of your day. Bye for now.